I commend Simeon Brown and I urge the House to support this bill.
I call Dr. Duncan Webb.
Madam Chair, the previous speaker talked long and hard about sending a message, and it's right. This bill, if passed, would send a message. It would send a message that we've given up and we've stopped caring. We both agree, and Mr. Brown and I were in Select Committee on this matter. We both agree that this is a very significant problem, but the only message that this bill sends is to the fearsome community that they should be afraid. It doesn't send a message that there's something that we can actually do. We know for a fact, and the statistics are there to be seen, that increasing penalties does not have a deterrent effect for people who are in these communities. There's a fallacy that these offenders are smart, thinking people who make calculated choices. They're not. By and large, they are of themselves addicted to substances and often mentally ill. So they are in the thrall of the very substances that we're trying to address. So what we need, and as my Supplementary Order Paper 170 sets out, what we need is to, in every decision we make, ask how can we address the root of the problem? And rather than incarcerating someone for long periods of time, we should first ask the question, is that the right response? So the first question should be, well, is this wrong? Is this social harm? Is this cancer that blights society best addressed by incarceration or by addressing the mental health needs of this person? So my Supplementary Order Paper accepts Mr. Brown's 8 years, but says this: when determining the length of a sentence, the court shouldn't automatically go through their usual tariff process, start at the midway mark, look for aggravating and mitigating factors. No, the first question should be the offender's need for health and mental health services, so that we can make sure that those persons' needs, the very thing that caused the social harm, is addressed, that we break the cycle, not compound the cycle. And compounding the cycle is exactly what incarcerating people for longer periods of time does. It's exactly what we don't want to do in this area of the law. What we need to be addressing in respect of drug law is a situation where we don't punish people for their own, essentially, illnesses and frailties, but we address those through the health system. The other thing that my Supplementary Order Paper would do, again accepting if Mr. Brown manages to get this 8 years through, is to look at the availability. When making a sentencing decision, look at the availability to access to the required health and mental health services for the offender. So if we have a humane prison framework which can address those things, then all well and good. That might be the right place. But we know that the prison system we've inherited is not one that has the resources needed to do exactly that. So the place for these people is in community facilities which can address their health and mental health issues. The signal we should be sending is not look out. These people are dangerous, they're harmful, we need to lock them away, we need to fence off part of our society, and we know for a fact that this afflicts our Māori communities particularly. So there's an element in there that Kiritapu Island's Supplementary Order Paper looks at. We need to be able to say no, these people remain part of our community. Even if they are incarcerated, we recognise they're coming back into our community and we want them to be useful, healthy members of our society. So when we make a sentencing decision in any drugs area, but especially in these particularly pernicious psychoactive substances, we need to look at the offender's needs for health and mental health. We need to look at the availability of those services, and we need to make sure we place that person in the area that's best for them best for the community, best for society. That is the signal we need to send.
I shall call Chloe Schwalbrook.
Thank you, Madam Chair. I just want to